As you can see, we're not in our usual employment law after hours studio today. However, sometimes big things occur. We're not able to get access to that studio, but we still need to bring you some news and information. Since we posted our OSHA ETS video last month, we've been receiving a lot of questions from viewers about whether the United States Supreme Court will uphold the Sixth Circuit's decision to allow the enforcement of the OSHA ETS mandating masks and testing. Although we do not yet know how the U.S. Supreme Court will act, I do have some information for you that may be helpful during your planning of whether to implement the OSHA ETS this month. That's next on Employment Law After Hours. As many of you may know, on January 7th, 2022, the U.S. Supreme Court will hold hearings about the enforceability of the OSHA Emergency Temporary Standard and the CMS vaccine mandate. These hearings follow the Sixth Circuit's decision last month to reverse the Fifth Circuit stay of OSHA's Emergency Temporary Standard, meaning unless the U.S. Supreme Court acts otherwise, the OSHA ETS will take effect as planned this month, January 2022. We previously posted an episode on the OSHA ETS and its requirements, which I will post a link to on the screen now. Now, before I begin today's episode, I do want to state I am an attorney, but I'm not yet your attorney. Today's episode is solely focused on kind of news and updates to the OSHA ETS and where we've been since our last episode. This isn't legal advice, but feel free to reach out to us if we're in your jurisdiction, and we may be able to assist you with your legal questions you have regarding the OSHA ETS. Although a decision from the Supreme Court may not end OSHA's efforts to implement masking and testing requirements for employees, as I discussed later in this episode, at the end of this video I will also discuss my personal thoughts of whether the U.S. Supreme Court will uphold the OSHA ETS and when we can expect such ruling from the U.S. Supreme Court. It is important to recognize that the U.S. Supreme Court is not deciding whether OSHA has the legal authority to implement its ETS, but whether the injunctions issued by the U.S. District Courts and ultimately upheld by the Fifth Circuit Court of Appeals are ultimately proper. In analyzing whether the injunctions were proper, the U.S. Supreme Court is first going to have to decide whether the OSHA ETS properly analyzes whether a grave danger exists before the United States. To support this grave danger, the government actually puts forth 153 pages of data and analysis going through why they believe a grave danger exists. On the other hand, challengers to the law say a grave danger can't exist if OSHA is only focused on employers with 100 or more employees. If a grave danger truly existed, then why doesn't this apply to all employers throughout the country? As we've previously stated, I believe that ultimately OSHA will enact such similar measures for smaller employers. However, at this time, OSHA has indicated that it's only focusing on 100 plus employee companies, as those are the ones that if they can get these rules into place as soon as possible, they can begin massive avoidance of that grave danger at a larger scale, meaning they'll ultimately curb many of the hospitalizations and deaths by focusing on these large companies and then ultimately shifting their focus to the smaller companies. In addition, challengers to the OSHA ETS state that, hey, how can there be a grave danger if you waited 18 months to implement this after the start of the pandemic? OSHA has responded to these challenges by indicating that, one, only recently did such testing become so widely and readily available. Second, it was the rise of variants such as Delta and now Omicron that ultimately led to OSHA needing to act. As many of you recall, Delta was seen as more widely transmittable versus, the other earlier variants of the virus. As I sit here today, I do not know how the U.S. Supreme Court will rule on both the OSHA ETS and the CMS vaccine mandate for healthcare providers. However, numerous surveys have been done of industry and legal scholars to determine what they think may happen. In particular, one study was conducted by Fisher Phillips, and they indicated that a majority of legal scholars that they surveyed had indicated that both the CMS vaccine mandate and the OSHA ETS will ultimately be upheld by the U.S. Supreme Court. In fact, a vast majority of those scholars overwhelmingly supported an upholding of the CMS vaccine mandate, while a simple majority simply favored the OSHA ETS being upheld by the U.S. Supreme Court. Very few legal scholars, as stated in the survey, had indicated that they think the U.S. Supreme Court will strike down both the CMS vaccine and the OSHA ETS. I personally believe that the U.S. Supreme Court will ultimately uphold the OSHA ETS because of, one, the rise of this Omicron variant and the need to alleviate some of the stress on our healthcare system, but also on the merits, as OSHA has established through its 153 pages of analysis and data that a grave danger exists. Therefore, they've met the legal standard to implement an emergency temporary standard through their existing regulations. In addition to not knowing how the U.S. Supreme Court will rule, we do not know when the U.S. Supreme Court will ultimately issue a decision on OSHA's ETS. It will unlikely come before the first deadline of January 10th. Hopefully, it'll come before the February 9th testing requirements take effect for the unvaccinated employees. Therefore, we are advising our clients to begin the process of implementing their policies and putting the mask wearing into place beginning on January 9th. We cannot be waiting for a U.S. Supreme Court decision at this time, as the OSHA ETS is not currently stayed. OSHA could begin its enforcement on February 9th as expected, unless a U.S. Supreme Court decision is rendered before that time. Therefore, have those policies in place over the next week and begin your mask wearing for unvaccinated employees. Finally, as I teased in the beginning of the episode, this may not yet be the end for OSHA's requirements of testing and masking for unvaccinated employees. As many of you may know, OSHA, during the process of issuing its emergency temporary standard, also filed preliminary rules for notice and comment for permanent rules requiring masking and testing. That notice and comment period is quickly coming to an end this month, and once it's done, OSHA can then begin the process of actually moving these rules from the emergency temporary standard over to a permanent rule basis, thus allowing them to escape the requirements of proving a grave danger to the public. I do want to say we feel for you as the employer community in the uncertainty that these court decisions are having as you begin to plan and implement your policies in your workplace. We really appreciate you tuning into our channel for those updates, and we'll continue to bring you those updates as soon as we can after news develops. I expect a lot of episodes to come out over the next couple of weeks regarding these issues, so stay tuned. That's actually why we're in this secondary studio today, as we did not want to waste time getting this video to you while our other studio is in use. So again, please hit that subscribe button if you'd like to be informed about our future episodes and future updates, and we'll see you next time.